everybody, and welcome to the launch of Volume 8 of the UK Supreme Court Yearbook. Now, I want to say it's lovely to have you all here. It's lovely to have the Yearbook, but it's nothing to do with us. There are indeed, I'm quite sure, Supreme Court justices who have never heard of it. It is completely independent of the court, and that's its virtue. So it can say nice things about us, or rude things about us, or properly considered things about us, and that's okay. But I just don't want you to think it's got anything to do with us. So now I'll hand you over to the people with whom it does have something to do.
Thank you, Lady Hill. Well, welcome everyone, and thank you very much for joining us this evening. My name is Daniel Clarry, and I am the Editor-in-Chief of the UK Supreme Court Yearbook, which is, as Lady Hill has mentioned, is an independent publication that critically reviews the jurisprudence of the court each year. And we're here tonight to launch a new volume, and we are up to our 8th volume of the UK Supreme Court Yearbook at this very special event. The format for this evening will be that I will shortly hand over to Lord Pannick, QC, to say a few words by way of introduction to the topic of the keynote address and reply. Professor Sir Geoffrey Jowell, QC, will give the keynote address, and Professor Timothy Endicott has kindly agreed to give a reply to that address. There will be some time for questions and discussion after Professor Endicott's reply. We are, of course, gathered here this evening in this beautiful courtroom, in this wonderful courthouse, to launch the 8th volume of the UK Supreme Court Yearbook. At 684 pages in length, Volume 8 of the Yearbook comprises 44 contributions from 57 authors, and the table of contents reads somewhat like a who's who of the UK legal profession. I won't say too much about the specific contents of the yearbook because it features so many excellent chapters, and I think those are better discovered by readers. I also think everyone is very keen to hear from our distinguished speakers here this evening. However, due to its relevance to this evening's lecture, I will just draw your attention to the symposium in part 2 of Volume 8, which is titled Firing the Brexit Bullet, Who Pulls the Article 50 Trigger? The symposium offers a deep engagement with the landmark case Secretary of State for exiting the European Union and Miller, which is occasionally referred to, as you know, Article 50 case or the Brexit case, but most commonly Miller. And I would like to thank Ms. Gina Miller for not only lending her name to the Article 50 Brexit case, but also for joining us here this evening with her husband, Alan. One cannot, of course, put together a 684-page book featuring contributions from 57 distinguished authors without accumulating a number of debts of gratitude. And I would like to express a few words of thanks on behalf of the core management team responsible for the overall publication of the yearbook. And there are essentially 4 of us. There's me, and then Sydney Richards, who is our Chief Technology Officer for the yearbook. There's also Valentine Jutner, who is our Chief Information Officer. Unfortunately, he couldn't be here this evening. He's in Cambridge, Massachusetts. And finally, Sarah Clarry, who is our General Counsel and never fails to counsel me generally. On behalf of the 4 of us, we would first of all like to thank the 57 people who contributed chapters to the new volume, and also our illustrator, Robin Suckertorn. We'd also like to thank our sub-editors and the members of our advisory board. We would like to acknowledge Quinn Emanuel, who kindly sponsored the event this evening, and in particular, we would like to thank the co-managing partners of that firm, Sue Provisa QC and Richard Eastman. I would also like to acknowledge Duncan Watson, who is also a partner of Quinn Emanuel, and he unfortunately couldn't be here this evening because he's in South Korea. We are very grateful for the support we receive from the UK Supreme Court itself, even though we are an independent publication, both in terms of its justices who publish chapters with us from year to year and also attend our events. And there are a number of the justices here this evening, and also I acknowledge Lord Millett as well. I would also like to thank the court's executive staff, especially the Chief Executive, Mark Ormerod, and the Head of Communications, Sophia Lynham-Biggs, who couldn't be here this evening as they have been in Northern Ireland, as I understand it today, making arrangements for the court to sit in Belfast in April. We also acknowledge the Communications and Outreach Manager, Tim Malone, the Events Manager, Albanese Lou Quigke, the broadcast team, especially Andy Watson, the Supreme Court's Librarian, Paul Sandals, and finally David Mills and his staff for catering for the drinks reception. We'd also like to thank the bookstore Wildy Sons for coming along this evening and setting up a stall in the lobby so that everyone could peruse their and our books during the drinks reception. Wildy Sons, of course, have been selling law books in Lincoln's Inn Archway since 1830, and we're very privileged to have the Yearbook stocked in their wonderful stores in Lincoln's Inn Archway and Fleet Street, as well as online. Finally, we'd like to thank our speakers, Lord Pannick QC, Professor Sir Geoffrey Jowell QC and Professor Timothy Endicott, for not only contributing to the 8th volume of the Yearbook, but also for accepting our invitations to speak this evening in this format. It is often said that speakers need little by way of introduction, but that is certainly true of these particular speakers. Lord Pannick, Sir Geoffrey and Professor Endicott are quite simply among the most distinguished constitutional lawyers, I think, in the country, and we are very privileged to be able to hear from them this evening. I cannot do justice to all of their significant achievements in their very impressive careers, but I only mention a few things from those achievements by way of, to give some sense of their profiles. So Sir Geoffrey is a barrister at Blackstone Chambers and is an emeritus professor of public law at the University College of London. Sir Geoffrey was the inaugural director of the Bingham Centre of the Rule of Law and has provided extensive advice on rule of law standards in a number of countries. His many publications include Dismiss Judicial Review with Lord Wolfe, amongst others, and The Changing Constitution with Professor Dawn Oliver. He is a bencher of the Middle Temple, an honorary fellow of University College London and Hertford College, Oxford, and has been awarded honorary doctorates from the Universities of Cape Town, Athens and Paris. Professor Endicott is a professor of legal philosophy at Oxford University. He is a fellow in law at Balliol College and served as Dean of the Oxford Faculty of Law for 8 years. He holds degrees from Harvard University, the University of Toronto and Oxford. He is the general editor of the Oxford Journal of Legal Studies and has authored many influential works, including his books Vagueness in Law and the multi-edition text Administrative Law. Professor Endicott has thought deeply about the basic constitutional principles that justify certain forms of judicial control of the executive conduct of government, which is the topic of Sir Geoffrey's address and Professor Endicott's reply. Lord Pannick is a barrister at Blackstone Chambers, a crossbencher of the House of Lords, a distinguished fellow at All Souls College, Oxford, and a member of our advisory board for the UK Supreme Court Yearbook. In addition to those affiliations, his name has come, I think, to define a generation of barristers. I think he's unquestionably among the best of the best in the UK legal profession in the current generation. In addition to the landmark case of Miller, which is the subject of the discussion this evening, Lord Pannick has appeared, of course, in many high-profile cases, including the Spycatcher affair. It therefore comes as an honour for me to speak before him in Courtroom 1 of the UK Supreme Court, which will quite possibly be the only opportunity that I get to do so. Without further ado, I hand over to Lord Pannick.
Thank you very much. Thank you for that introduction. I think this will be the only opportunity I will have to speak from the President's chair in the Supreme Court. Ladies and gentlemen, this is a short overture before the main performance by Geoffrey and Timothy. Just to give you the background to the Miller case. On TripAdvisor, if you look it up, you will see that the United Kingdom Supreme Court receives a rating of 4.5 stars out of 5. And if you look at TripAdvisor, you will see there are comments by Steve D. And Steve D says this, he says, interesting building, but not much to see. This suggests to me that he chose the wrong day to visit. The Gina Miller case was unusual. Sky News produced a highlights programme each evening with expert commentary by my friend Joshua Rozenberg. Betfair offered a book on the results, with the odds changing as each counsel made his or her presentation. The BBC One satirical programme, Have I Got News for You, included a reading from the transcript of the hearing, an authentic reading, although the authenticity was somewhat spoilt by the fact that they all put on wigs for the occasion. The Daily Mail published a pre-hearing article which gave each of the 11 Supreme Court justices a Europhile rating of 1 to 5. Of course, it bore no relationship whatsoever to the judgments either of the majority or those in the minority. I had my share of insulting emails, as one anonymous correspondent put it, quote, "You are just a bunch of slime ball lawyers." But the publicity for the case did, I think, do much to educate the public about the virtues of our legal system. A private citizen, I don't say an ordinary citizen because Gina Miller is an extraordinary woman, a private citizen can and did sue the government and take it to the highest court of the land in relation to an issue of law of enormous public importance, of great importance to the future of the country. The government was then required to justify the legality of its conduct in public before independent judges who gave a reasoned judgment. This dispute, the dispute in the Miller case, was really a dispute about the allocation of state power, an issue resolved in many countries by the use of tanks or other displays of force. In this country, happily, the government is reliant on the considerable skills of advocacy of Treasury Counsel, my friend James Eadie. The judgment reminded Parliament that it has power to control the executive. Now, for counsel, a hearing in the Supreme Court is part university tutorial before 11 demanding tutors and part all-in wrestling bout. The judicial moves can and often do take counsel by surprise, knocking them off balance, occasionally throwing them out of the ring. And I always reflect on the 1997 Australian film, The Castle, where there is a hopeless advocate, Dennis Denuto, and he's asked by the Australian judge what section of the Australian Constitution he says has been breached. There is a painfully long pause as Mr. Denuto shuffles his papers. He eventually responds, "It's the vibe of the thing." In the Gina Miller case, as in all great cases, there were competing vibes. On the one hand, parliamentary sovereignty, and on the other hand, executive responsibility for foreign policy. And it's the competition, the conflict, that made the case difficult and important. And I very much look forward to hearing Geoffrey and Timothy's serious analysis of the issues of law which were argued and which were decided. Thank you very much.
Thank you, David. Ladies and gentlemen, I've always been told never speak after David Pannick, but here we are, nothing I can do about it now. The Miller case posed the Supreme Court with a question at the heart of any democracy: what are the respective powers of the executive, of Parliament, and the people expressing their views through a referendum? In a country without a written constitution, these issues are not clearly delineated. A codified constitution might not achieve total clarity, but at least would provide more certain standards to guide the court and to inform everyone of the rules and principles that govern our public decision-making. The case was provoked by the claim by the Prime Minister that following the June 2016 referendum, it was for her to decide whether the UK should leave the European Union. Article 50 of the Treaty of the European Union states that the decision to withdraw should be decided in accordance with a member state's own constitutional requirements. And Mrs. May claimed that our requirements invest the executive branch of government with that authority under the prerogative power to direct international affairs. Mrs. Miller, the lead claimant, submitted to the contrary, that it was for Parliament rather than the executive to decide whether to set in motion the wrenching of our country from its duties, obligations, and benefits under the terms of its membership of the EU. Other constitutional questions were raised in the case. Should Scotland, or Northern Ireland in particular, consent to the decision to leave the EU? And underlying the whole litigation was another fundamental constitutional conundrum, namely, should the courts enter this political arena at all? And then outside the litigation, the heat generated by the case, particularly at first instance, raised a number of yet further constitutional issues, such as the extent to which the press were free to call into question the independence of the judges in the case, to make suggestive comments about their personal lives, and to call them such as enemies of the people. And perhaps most brazen of all, to deprecate the courageous claimants, Mrs. Miller and Mr. Dos Santos. And this in turn raised the question as to whether, in the light of that media turbulence, the Lord Chancellor had sufficiently exercised her constitutional duty to uphold and defend judicial independence and the rule of law. On the day of the hearing, the Supreme Court, through deft organisation and a welcome spirit of transparency, opened its doors to constant coverage by the media of Council's submissions. During the breaks, experts analysed the state of play on the model of a sporting fixture, speculating on which judges had drawn more blood from which council. It was all quite exciting. As interesting as it was, or exciting at least for the legal nerds, because the general public, I believe, was soon lulled into the realization that the nature of the argumentation was miles away from the political rumble which some of the press had led them to expect. Although no one could have been disappointed by the brief excursus when Lord Pannick, in a response to a question by Lady Hale, burst into a brief adaptation of the famous Gershwin song, "You Say Tomato, I Say Tomato," in the context of the case authority of De Keyser or De Kaiser. My article for the Supreme Court Review considers all of these constitutional issues, but in the time allowed, I will just deal with three of them: the status of the referendum, the scope of the prerogative power and devolution issues, and devolution issues on the question of the convention, those three issues, and I will end with more general remarks about the constitutional and political impact of the case. On the question of the referendum status, the government argued that the response to the result of the referendum was a matter for the executive, and argued that Parliament could not have intended that, upon the electorate voting in favour of leave, the same question should be referred straight back to it, to Parliament, for its consideration. The reply of the majority on this was firm, namely that the effect of any referendum must depend upon the terms of the statute which authorised it. Previous referendums, such as the 2011 referendum on the voting systems, had specifically stipulated that a change in the law would be an inevitable consequence of a positive vote by the electorate in the referendum. But the 2015 Referendum Act about setting up the Brexit referendum simply authorised the Brexit referendum, making absolutely no provision for any consequences of its outcome. It provided only that the referendum would be held. For that reason, it was held that any force the referendum might have remains political, but not legal. Turning to the central issue in the case now, the prerogative or Parliament, Lord Hughes summarised the issues at play here in an admirably accessible way. He said that there were two rules, both of which were accepted by both sides in the case. And the question is simply which rule prevails in the circumstance. Rule 1, he said, was stated in the negative, that the executive cannot change law made by an act of Parliament nor the common law. And Rule 2 states that the making and unmaking of treaties is a matter of foreign relations within the competence of the executive. Mrs. Miller, while not denying Rule 2, foreign relations power of the executive to make and unmake treaties, she did by no means denied that, but she contended that that power stops short at the point where UK statute law is changed. And she submitted that an Article 50 notification would lead to a change in UK domestic law and should be decided, therefore, by Parliament. The Divisional Court held unanimously in favour of Mrs. Miller. It was held that although Article 50 operates on the international plane as a treaty obligation, domestic legislation, namely the European Communities Act of 72, the act that authorises the incorporation of EU treaties into UK law, that although Article 50 operates on the international plane, the Communities Act, European Communities Act 72 authorises the incorporation of those treaties into UK law, and the withdrawal from those treaties by means of Article 50 would therefore result in changes in domestic law involving the loss of a number of rights, such as employment protection, the right to vote or stand for election in the European Parliament, detailed provisions about VAT, agricultural grants, fishing quotas, and so on. And these could only be changed by Parliament under the principle of parliamentary sovereignty and not by the executive. The government's appeal then went to the Supreme Court, where a full bench upheld the decision by a majority of 8-3. The minority in the Supreme Court disagreed with the approach of the Divisional Court. And the minority argument went as follows. The 1972 Act gives effect to whatever UK's international obligations happen to be from time to time created or arising by or under the EU treaties. And Lord Reid thus interpreted the 72 Act as giving effect to the EU in domestic law in a way that is inherently conditional. It's conditional on the application of the EU treaties to the UK, and therefore on the UK's membership of the EU. This is shown, he said, by the fact that the condition was not satisfied when the 72 Act initially came into force, because the treaties then did not apply to the UK. As he said in his dissent, the satisfaction of the condition some months later depended on the decision of a UK entity. And that entity was not Parliament, which passed the 72 Act, but the Crown's exercise under the exercise of its prerogative powers. The content would return to zero, he said, if the condition ceased to be satisfied as the result of the UK's invoking Article 50. In short, Lord Reid contended that although changes in EU are brought into domestic law through the 72 Act, once the UK ceases to be bound by the EU treaties, which is a decision that the minority felt the executive are competent to undertake under their prerogative powers in relation to international affairs, once that happened, there are no rights or powers which, in accordance with the treaties, are to be given legal effect in the UK. Furthermore, since the Act is silent on the question of whether Article 50 of the TEU should be invoked by Parliament, no implication can be derived that Parliament has, by necessary implication, deprived the Crown of its prerogative powers. That was the dissenting view. The majority of the Supreme Court through a judgment of Lord Neuberger, upheld the judgment of the Divisional Court in favour of Mrs. Miller. Their judgment is based both on pragmatism and constitutionality. On the pragmatic side, like the Divisional Court, they recognized as a fact that our law is shot through with rights and obligations that have been pouring out of the EU for well over 40 years, which should only be changed by those we have elected to make or amend or repeal laws on our behalf. However, the majority went further than this, effectively blindsiding virtually all the commentators and bloggers, some of them in this room now, including myself, and perhaps even all the advocates in the case. They buttressed their conclusions with a constitutional argument which went as follows. The 72 Act, incorporating EU law, etc., is not just any statute. It is a constitutional statute, a status that has been reserved in the past to those few statutes, and acknowledged, by the way, as possible even by Dicey, to those few statutes that are constitutionally significant over the years. They've sometimes been called super statutes. And these statutes have special weight and are protected from implied repeal. Parliament has to be clear to change them. Ambiguity will not suffice. But this particular statute, the 72 Act, is particularly significant even among constitutional statutes because it uniquely altered our constitutional arrangements by providing that an international source of law be grafted onto and indeed be above our established sources of law. In other words, it made EU law paramount, even to the extent that the courts could disapply our Parliament's laws, which were in conflict with EU law. Lord Neuberger said that the 72 Act effectively operates as a partial transfer of lawmaking powers or an assignment of legislative competences by Parliament to EU lawmaking institutions, so long as Parliament wills it. Yes, the 72 Act gives effect to EU law, but it is not the originating source of that law. Its effect is to constitute EU law as an independent and overriding source, said the majority, of domestic law. Withdrawal from the EU institutions therefore constitutes a fundamental change in the constitutional arrangements of the United Kingdom, and such changes must be done by Parliament and not by the executive under its prerogative powers. The third issue in Miller was whether the UK government could make the significant decision to depart from the EU without the consent of the developed nations. The situation in relation to Northern Ireland is perhaps the most complex, given that its devolved powers are partly based upon international agreements, the Anglo-Irish Treaty and the Belfast Good Friday Agreement. Our pattern of devolution has created perhaps the most significant differences in our constitutional fabric since Dicey's time. Although the powers devolved to the relevant legislatures in Northern Ireland, Wales and Scotland do not affect the power of the Parliament of the United Kingdom ultimately to make laws for those nations. There is a convention known as the Sewell Convention, after the former Minister of State in the Scottish office, that Westminster would not normally legislate with regard to the devolved matters in Scotland without the consent of the Scottish Parliament. There's a similar convention in Northern Ireland, and arguably even greater necessity in that country for consent. The Supreme Court fully acknowledged that this convention has been observed over the years, and importantly, has more recently received statutory recognition through Section 2 of the 2016 Scotland Act, which alters the former Scotland Act that governs lawmaking powers to the Scottish Parliament to read, firstly, that the section does not affect the power of the Parliament of the United Kingdom to make laws for Scotland, and secondly, but it is recognised, here it incorporates into the statute, the Sewell Convention, the Parliament of the United Kingdom will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. The governments of Scotland and Northern Ireland, to some extent Wales as well, submitted that the Sewell Convention should be applied. The Supreme Court did not underestimate the importance of constitutional conventions, some of which play a fundamental role in the operation of our Constitution, they said. However, it held that the judges are, quote, neither the parents nor the guardians of political conventions. They are merely observers. While the existence of conventions could sometimes be recognized, their validity cannot be the subject of judicial proceedings. As for the Sewell Convention, it operates only as a political restriction on the activity of the UK Parliament. Since its function is in the realm of politics, they said, rather than law, the policing of its scope and the manner of its operation does not lie within the constitutional remit of the judiciary, which is to protect the rule of law. Even the affirmation of the convention into statutory form did not permit its judicial enforcement, since the purpose of the legislative recognition of the convention was to entrench it, but to entrench it as a convention, not as a justiciable rule. So, was Miller rightly decided? Very shortly, first on the referendum point, the decision was surely right, as the Referendum Act 2015 could clearly not be intended to be binding on the executive, at least in a representative rather than a popular democracy. On the question of whether the consent of Northern Ireland or Scotland was needed, the conclusion that was reached may well be correct, but with respect, the treatment of the force of conventions somewhat belittles the significance of these key features of our constitutional structures. The Supreme Court failed in any detail to explain or explore the difference between the recognition of conventions and a consideration of their validity. The door should surely have been left ajar to an assertion that a relevant convention might raise a presumption that it should be followed in a manner analogous to the principle of legality, which Miller otherwise endorsed as a principle of constitutional construction. For one thing, conventions can be crystallized under our flexible constitution into the common law. Sir Ivor Jennings pointed out that constitutional usages about the supremacy of Parliament themselves were initially conventions, which were incorporated into the common law at the end of the 17th century. More regrettably, the court did not in any way seek to justify their view that the incorporation of the Sewell Convention in the Scotland Act intended to keep its status as a convention and not as a binding rule. But what about the central issue of the case, the contest between Lord Hughes's Rule 1 and Rule 2, executive versus Parliament? In his article in the Supreme Court Review, Timothy Endicott says that the majority judgment in Miller lacks legal authority. With the greatest respect, I disagree. In 1972, Parliament authorized the grafting of an international source onto and above our established sources of law. Democratic instinct alone surely suggests that it's not for the executive to cancel that instruction and restore Parliament's sovereignty. To require Parliament to make that decision does not involve the courts in making law or intruding into the political arena. The majority in Miller arrived at the conclusion through an appropriate exercise of constitutional interpretation, justified by well-established principles, applying to the kind of democracy we are, namely a representative democracy where the executive has some limited power to act on its own, but with a strong presumption, surely, that it is the elected representatives of the people who make fundamental constitutional decisions, that is, decisions which shape the framework of our public decision-making structure. This is the kind of judgment, the kind of reasoning, kind of justification that is done by constitutional courts all over the world, whose role it is to delineate the necessary features of democratic society. Insofar as criticism may be made of the majority in this case, it is not that they entered too far into the arena of constitutional interpretation, but that they arguably didn't go far enough. There is no doubt that the sovereignty of Parliament in relation to the executive in this case and in relation to the referendum was and should have been the controlling principle. However, given that Miller was probably the most publicized case in generations, the message that the public take away in the case is of a somewhat 19th century view of a unitary state in which our sole constitutional rule appears to be Dicey's harshest version of parliamentary sovereignty. Namely, as was quoted a couple of times in the case, that Parliament has the unfettered power to, quote, make or unmake any law whatsoever. A most extravagant view, which even Dicey himself later qualified. Was it really necessary so categorically to adopt the assumption that parliamentary sovereignty constitutes the foundational rule of recognition in our law, a term adopted by the late Professor Hart, referring to a rule or rules accepted by the officials of our legal system? Probably none of the justices in this case would have risked engaging in the kind of broader constitutional disquisition in the manner of the late Lord Diplock. Yet, should not the court have considered somewhat more carefully the consequences to our modern understandings of our Constitution, especially since it is not codified, of some of the categorical endorsements of parliamentary supremacy, and should they have not at least recognized, since people will look to this case in particular for guidance, that our Constitution is founded on a set of principles which are fundamental to democracy, just one of which is the principle of representative government, which justifies, by the way, the sovereignty of Parliament. But these principles also contain others such as equality, liberty, and the rule of law, as well as some recognition that our formerly centralized unitary state has been transformed through devolution into a multi-layered one. Again, let me emphasize that I applaud the holding in Miller and the grounding of the majority judgment, particularly in constitutional principle, and that I well understand, too, that any further excursions into the limits of parliamentary sovereignty may be regarded as unnecessary to the decision, and indeed, perhaps even a hostage to the fortunes of an already embattled judiciary. However, surely some reference might have been made to the fact that hard Dicey orthodoxy has been challenged in cases such as Jackson, where some of the law lords seriously questioned its supremacy over the rule of law in some stark hypothetical circumstances, such as the abolition of Parliament or the abolition of judicial review. The principle of legality and the notion of a constitutional statute were adopted in Miller, but mention might have been made of the way that they've been employed in other contexts to soften parliamentary sovereignty in favor of the rule of law or fundamental rights, at least where the statute was silent or ambiguous. The historical shift of authority from Crown to Parliament should not only be seen as the reallocation of sovereignty from one locus of power to another, it also heralds a transition from unfettered public power to a culture of rights, accountability, and justification. Of course, this one case cannot be expected alone to bring our elusive Constitution into sharp focus, but it does highlight graphically that seeking to identify our fundamental constitutional norms in a holistic context is, in the words of Lord Bingham, like navigating in a desert without map or compass. How much constitutional clarity can we claim when the government, in this case, seriously argued that an open referendum binds the executive, and where constitutional conventions, which countless authorities have regarded as the glue of our public institutions and official behavior, were not, even if they were recognized in this case, in circumstances that are not explained, They're relegated, in fact, to a few lines with the status of mere political bargains, even where the terms of the convention have been incorporated in a statute. Our constitutional principles may be able to be discovered in the crevices of different cases and different pronouncements, but surely the time has come to consider the codification of at least some of them in the interests of both clarity and accessibility, not only for the benefit of our public decision makers and lawyers, but perhaps especially for the understanding of the public at large. And finally, just a few quick words on Miller's political impact. Some cases have an immediate impact in altering behavior, others less so. What has been the impact of Miller? Did members of Parliament leap to the constitutional opportunity to exercise their power under Article 50 of the TEU to the exclusion of the executive? Did MPs and members of the House of Lords seize the judgment as an indication of their sovereign power to steer Brexit according to their will? Quite the contrary. Having won the constitutional battle that had absorbed so much time, expense, and energy, Parliament meekly ceded the power to direct the pace and the shape of Article 50 to the executive, granting virtually unanimously support to a very short bill authorising the government to give notice under Article 50. The Prime Minister conceded only at the time, some unspecified form of parliamentary scrutiny before the deal was done, and on the 29th of March 2017 notified the UK of the UK's intention to leave the EU. Parliament is being somewhat more assertive during the passage of the current EU withdrawal bill. But only time and the intricate relationship between law and politics will tell whether Parliament will ultimately assume the responsibility which Miller so rightly held was in their hands. I ended my article in this volume with the words, "La commedia non è finita," and 14 months after Miller was decided, we might wonder whether the comedy has even barely begun. Thank you.
Thank you very much, Jeffrey. Thank you, if that's the word I'm looking for, Daniel. I think Daniel invited me to speak to you because Jeffrey and I disagree. And so that sets me up. When we were law students, we always wanted to get the side on the moot that obviously had to lose because there was nothing that we could lose in the argument of the moot and the opportunity to make some novel argument. I'm not exactly in that sweet position because of the judgment of Lord Reid and of Lord Carnwath and Lord Hughes. And I don't even have to explain too much my view on the law because you can read it there. And I agree with Lord Reid, and I think he explains the law beautifully. And Lord Carnwath adds what Lord Reid was taking for granted to do with the reasons why it's actually the dissenting view, it's actually okay. So I'm going to stand up for arbitrary executive government on this issue, or so it seems, and explain why it's not as bad as it seems. And I want to do so by pointing out a constitutional reform that got us where we are that is too easily forgotten. And I want to make a plea. And the plea is that you people, thinkers and doers, should think about executive power in our Constitution and what it's for, because we've got a 1,000-year history of not thinking what it's for. And before I start, I want to congratulate and thank Gina Miller for generating an account of our Constitution that law students and students even who are not studying law are going to be reading for generations to work out for themselves what they agree with and what they disagree with in the account of the principles of our Constitution. Very briefly, you and I have rights under European Union law, and to have those rights we need two things. We need the UK to be a member state, and it is because of the Treaty of European Union. successor to other treaties. And we need something else. We need the rights that arise under the treaties to have effect in UK law, and we've got that too, because the European Communities Act did that. It gave effect. Deciding that the treaty is to have effect in UK law is not the same as deciding that it's not to be terminated in the ordinary exercise of the treaty prerogative. If you tell your mum and dad that you're going away to college, and they say, well, you do what your tutors tell you, they have not told you not to drop out. And that's the case no matter how stupid it would be to drop out of college. The treaties create rights that have no effect unless they have a source in English law and Scottish and Welsh and Northern Irish law. And the statute gave them effect. Now, and this, Lord Reid explains this, the Act itself, the European Communities Act 1972, does nothing to interfere with the prerogative powers of the Crown, unless we ought to, and he doesn't say this, I don't think, but there's one ground on which you might say that the Act itself interferes with the prerogative, and that's if the giving effect does something in UK law that the prerogative cannot properly be used to undo. And that is, I think, the operative basis of the majority decision in the Miller case. The majority reasons assert the constitutional importance of the decision to trigger Article 50. And they express the view that that's too important for ministers alone. And I think that's the operative proposition of the judgment. It's what Jeffrey refers to as the democratic instinct, a feeling expressed by the majority, eight judges out of 11, that this is too important for ministers to do. So important, given our constitution, that it needs Parliament. I think that's the basis. I think of what the court did as a constituent act. By constituent, I simply mean constitution making. And I say, as Jeffrey mentioned, that there's no legal authority for it because there is no source for the proposition that treaties that are too constitutionally important cannot be undone by Her Majesty's government. So I think of it as a constitution-making act. You might describe it differently. Jeffrey and I were talking about Ronald Dworkin. Ronald Dworkin would have loved the Miller case, and he would have seen in what the court did, not merely looking for some source, some authority that said that the government can't do that, but exercising a judicial duty to identify on behalf of the community a scheme of principle that is ours because it fits the whole historical pageant, and shows that the power of the state is being used with integrity. And so you might say that's what was going on, the identification of the principles of the Constitution. I think it's, I would interpret it as a whole new constitution-making act. And there's a problem for legal philosophers that, of course, the barristers and the judges don't have time for, to identify the difference between the constructive exercise of identifying our principles on the one hand, and the act of making a new constitution for the United Kingdom. And let me emphasize that I'm not against judicial constitutive acts. They can be heroic and great. And let me mention two examples: the case of Proclamation 1611, in which Sir Edward Coke, a judge, told the king that he couldn't set up a revenue-raising scheme without the authority of Parliament. Read it, and you will find authority offered that really isn't. There really is no authority for what Sir Edward Coke held in that case. I think it was a constituent act, a constitution-making act, and brilliant and heroic, and of course unsuccessful, because we didn't get there until the Bill of Rights 1689. It took Parliament to establish that the Crown couldn't raise taxes without grant of Parliament. Here's another, the case of prohibitions. Sir Edward Coke, same judge, stands up to the king and says, "You cannot judge cases in person." Remarkable. He's a bit terrified of the king, and he has the guts to say that. And no authority for it. By definition, the king hadn't personally been judging cases for a long time, but no authority for the proposition that he couldn't, and Sir Edward Coke just said it, did it. That was great. Unsuccessful, of course, establishing judicial independence when the Crown can just sack you, and it was only the Act of Settlement 1701 that established the independence of the judges. But those two acts by the judge, constituent acts by the judge to create new elements in a constitution, and I think it's brilliant. And then, even if you agree with me that this was a constitution-making act, the majority decision in the Miller case, you ought to be in favor of it if there was a need for it. And there's the question. Now, how do we decide if there's a need for it? Look at the Constitution from the point of view of those two cases, proclamations separating the legislative power, paradigmatically legislative power to raise taxes, from the executive. And look at case of prohibition separating the judicial power from the executive. And you've got a picture of how we've always thought of executive power in our Constitution. Something to be taken away. And Sir Edward Coke didn't start this. Magna Carta, it's great, I'm not against it. Magna Carta 1215 is a list of things, 60 paragraphs of things the king mustn't. Things, I think it would have been voidable for duress if they hadn't already been things the king mustn't do. The barons list them down, and the king has to agree to it. And it doesn't say what the executive can do. Sir Edward Coke wouldn't presume to tell King James what the executive could do. We have a great tradition of thinking of executive power of government as a bad thing to be taken away, and nobody has ever said what it's good for. And by the way, I think it would be rather useful to understand what it's good for in order to work out what its limits ought to be and how it ought to be trammeled. Ronald Dworkin, we do this with Parliament, that's democratic. The courts, they're independent and principled. The forum of policy is the democratic legislature. The forum of principle is the court with the independent judges. What's the executive? It's not a forum. It's the state against which the law must protect us. We have a tradition of thinking of the executive as the baddies, and separation of powers as separation between the goodies and the baddies. And I think that's a mistake. And that's why the third constitutional reform is so important. Separation of legislative power, great. Separation of judicial power, great. And the third, and perhaps the greatest, is what happened by accident, without any design, after the Glorious Revolution, when the king couldn't raise taxes anymore, and eventually they realized they needed ministers who had the confidence of the House of Commons, and that gave us responsible executive government. And that's fundamentally important. One point on which perhaps Geoffrey and I, well, you might say it explains our disagreement, is Geoffrey's picture of Parliament as the representatives of the people, by contrast with the executive. And I think we should remember that the executive today is not King James. It's not King James. It's Queen Elizabeth II. This third constitutional reform turned us from monarchy into a monarchy in inverted commas. And today the executive is a body of representatives of the people, trammeled every which way by the House of Commons. It was this third constitutional reform, it wasn't complete in the 1770s, and that's why the Americans wanted a different form of government. It was complete by 1867 when Walter Bagehot, in his brilliant journalistic way, described the efficient secret of the British Constitution, cabinet government, accountable to the House of Commons for the executive work of government. 1867, that's when the Canadians, negotiating a new constitution for themselves and asking for the British government to introduce legislation into Parliament to create it, chose the Westminster system, because the executive would be people like them, the representatives of the Canadians, accountable to a House of Commons. It works, and it's a basis for the legitimacy of the treaty prerogative. It's essential for the treaty prerogative. The treaty prerogative is not a regrettable residue. We tend to think of executive power as a stubborn stain that has been partly but not entirely washed out of our Constitution. We haven't got rid of all of it yet. The treaty prerogative is actually essential for us as a community. We need it for the effective representation of the United Kingdom in international relations. Lord Reid quotes Blackstone saying that the prerogative in international relations requires unanimity, strength, and dispatch. That's right. I think that's really important. We need it as a community, to be one, and to work with other nations and with the European Union. We need it. And that's not enough. We need it, but it has to be responsible. And that's why the third constitutional reform is so important. Cabinet government makes the executive itself democratic. And then Brexit, in my view, and the decision to trigger Article 50 is a paradigmatically executive act. Lord Carnwath put it that triggering Article 50 is the start of an essentially political process of negotiation and decision-making. Don't even try to think about Parliament negotiating Brexit. Don't even think about the House of Commons negotiating Brexit. Impossible. Say what you like about any British government. We need the British government to be constitutionally responsible. That means the executive for this negotiation. Parliament can't do it. Lord Carnwath said, again, as I suggested earlier, explaining why Lord Reid's view of the law is not a view of the law that's constitutionally stupid. It's not constitutionally stupid for the law to be as Lord Reid said it is, because parliamentary accountability, the principle of parliamentary accountability, is fundamental, says Lord Carnwath, to our Constitution. The executive is accountable to Parliament for its exercise of the prerogative. Now, of course, the fact that we need the executive to conduct the negotiation doesn't mean, I hear you say, that they shouldn't need approval from Parliament in the form of a statute before they can start the negotiation. And in my view, the strongest argument for the majority in the Miller case is the prospect that the power to trigger Article 50, if it lies with the government, could be used arbitrarily. And the majority mentioned this possibility. And if that was a constitutional danger, then you might say that's a reason for the courts to engage in a constituent act to prevent the danger, to give us responsible government instead of arbitrary government. But I think that there has never at any point been any prospect at all of arbitrary use of the prerogative for this purpose. Imagine, it's not hard, you can imagine it. Not since before 2009, they would have had to negotiate a new treaty. So think about since 2009, and even imagine in your mind the prime ministers we've had since 2009. And imagine one of them waking up with feeling really mad and sore about everything, and writing a letter or an email triggering Article 50. And suddenly, bang, 2 years later, we're doomed to no longer be a member state of the European Union. You can imagine that. And if you imagine it, you're imagining circumstances in which the Prime Minister of the United Kingdom is not under the trammels that Theresa May is under, and that every other one of our Prime Ministers has been under since we had something called a Prime Minister. There is no actual prospect of triggering Article 50 by an arbitrary act of a Prime Minister, and we're only here because of the stupid referendum. So I think there is no risk, no constitutional problem that had to be met by the act of taking away this aspect of the Treaty of Prerogative. Remember, the power to terminate a treaty that's of major constitutional significance. And very briefly, if there was a problem, it wasn't solved. The EU Notification of Withdrawal Act, the Prime Minister may notify under Article 50 the United Kingdom's intention to withdraw from the European Union. It's not a triumph of responsible government. But you might say, here's the irony of our Constitution. The irony that the decision in the Miller case had no consequence because of the result. No legal consequence. It changed the debate, didn't it? And let's not forget that it's not as if Parliament hadn't heard about Article 50 before the decision in the Miller case. Parliament was involved, but after the day of the decision, Parliament's role became not the role of holding the government to account, but the role of debating proposed amendments in both houses to the government's proposal. So it changed the form of the debate, but didn't change the result, didn't change the government's purpose. And that everyone knew that we could see this coming because of the relationship between the executive and our Parliament in the Constitution. Now, so I've got it off my chest about why we wouldn't be subject to arbitrary government if the Prime Minister representing the United Kingdom had the authority to do what the court decided she had no authority to do. Is it because we call it the royal prerogative? Royal is undemocratic and prerogative sounds like arbitrary power. If we understand it as the executive authority of the government of the United Kingdom, then we can start to focus on the positive question. What's it there for? What do we want from them? And that question has to be answered in light of the way in which they're controlled and not free to act arbitrarily. Stupidly, perhaps, but not arbitrarily. Now, the future, Miller's effects for the future, does it have precedential effect? My colleague Rob Stevens asked me, suppose a prime minister decided that she wanted to withdraw the notification. So she tells everybody maybe there's been a general election, some seismic political situation, and that's what she's going to do. And she announces that she's going to withdraw the notification. Could you go to court and say, no, that's too constitutionally important, that exercise of the prerogative in managing treaty relations with another country? I don't know the answer to that question. I suppose the Miller case is precedent for the proposition that she needs a statute. I'm not sure. Are there other treaties that are so constitutionally important that, according to Miller, the government has no power to terminate them? Not the European Convention on Human Rights. It's got all sorts of importance, but it has no direct effect. The Treaty of European Union is unique. Unique. And then you might say it has no precedential effect, the Miller case, except I've read Christopher McCrudden's and Daniel Halberstam's essay in the volume on Northern Ireland, and it is an eye-opener. And I already knew that there's a problem drawing a land boundary between EU and non-EU on the island of Ireland, and they spell it out in words of one syllable. And I come out of that, reading that article, thinking that the British-Irish agreement within the Good Friday framework may be so constitutionally important that it would be subject to the rule, the doctrine in the Miller case. And then, let me ask you this, is it just treaties? Why not say that the multi-party agreement with people, organizations, parties within Northern Ireland, is that subject to the rule too important for the government to tear up? I don't know the answer to these questions. How about acts in general of prerogative that are too constitutionally important for the executive? Do you know what? I think that appointing members of our legislature is too constitutionally important for the executive to carry it out responsibly. But I'm not recommending that anyone go to court and ask the judges to hold that the prerogative cannot be used to make appointments to the House of Lords. So the reach of the case is unclear. It may not have any precedential effect, but I think perhaps it does in respect of this one incredibly important treaty between Britain and Ireland, and there may be other effects that it has. I don't know whether Geoffrey says that the legal effect, potential legal effect of conventions is belittled by the majority judgment. I have to say I'm skeptical about the legal force of conventions. Think of a good example of one that very definitely we know what it is and that it ought not to be broken. The convention that the monarch gives royal assent. Imagine a monarch, now you can't even imagine this with Queen Elizabeth II, but imagine a monarch who refuses to give royal assent. Well, I would propose that there is simply no ground whatsoever for the courts to be involved in the resulting constitutional crisis. We would need what we got in the 1680s, which is those people in Parliament to do something quite irregular. It was quite irregular what they did in the 1680s. And they would need to engage in a constituent act that the courts would not be well placed to do. And I think that I would say the same as about the Sewell Convention, that there's not great promise for good, responsible governance in the United Kingdom in the courts deciding to say what it requires or whether it should be complied with. Parliamentary sovereignty, has the Miller case gone back on the things that were said in the Jackson case? That's a really interesting question, and I don't know the answer to it. So I won't speculate on the speculative things that were said in the Jackson case and whether the Miller case has gone back on them. There are some questions about the future of the United Kingdom Constitution after the Miller case. And here's my plea. When you think about those questions, or when you act to resolve those questions, try to do so in a way that understands what the executive is there for. Because only if we get that will we be able to make wise decisions as a community on what it mustn't. Thanks.
Thank you very much for those addresses, Lord Pannick and Sir Geoffrey and Professor Endicott. We do have some time for some questions and a little discussion, so if anybody has any questions, then please feel free to raise your hand. Ms. Gina Miller. Yes.
Wording that's in the withdrawal bill, and if that suffices in the case of the Liverpool case.
Well, I mean, there is a provision, as you say, in the withdrawal bill that requires parliamentary approval for the agreement, if any, that is reached. And I think this is an indication of where I would disagree with both Geoffrey and Timothy, because they both were suggesting there's been no immediate effect of the Miller judgment. And I don't agree with that. I mean, from my perspective, what happened after the judgment was that the Prime Minister struggled to get the notification bill through Parliament. She did get it through Parliament, but it was a struggle. And that concerned her because she knew that she would have to get through Parliament the agreement, if any, that was reached. And Parliament was energised by the Miller judgment. One only had to speak to members of Parliament and members of the House of Lords that their powers were put centre stage. The Prime Minister then became concerned what was going to happen. And she realised she had a strong position in the opinion polls, and she called an election. And one of the main reasons she called an election was a concern about getting the agreement through Parliament. And we know what happened as a result of the election. And she is struggling to get the withdrawal bill through Parliament. She will struggle to get an agreement through Parliament. And the issues are coming to the boil. And there's lots of legislation along the way. So I think the case has actually had a real significance in the short term in energising Parliament and concerning the executive about the future. And I certainly don't agree with Timothy that we can all rest content with the executive power, just to traduce what he was saying. I mean, I don't want to be governed by Theresa May and her cabinet, who are meeting today in Chequers deciding the way forward, any more than I want to be governed by Tony Blair and his sofa cabinet. It seems to me Parliament should be in charge, and you can't change the law without Parliament's approval.
I was going to follow that up. Whilst the executive, which you described as represents the people trammelled in every way by Parliament, is certainly not James I seeking to do the opposite. It seemed to me some of the logic of what you were saying was international affairs are necessarily outside the prerogative of judicial review, effectively, which is decreasingly true. The logic of what you say might be taken as an argument for more and more Henry VIII clauses. I think that there are some international affairs which are clearly unsuitable for judicial review, but there are others, and as I say, if you look at the case law increasingly, where the considerations of urgency, dispatch, which you cited as the reason why international affairs are left to the executive, actually don't apply.
Well, thank you. And I do, of course, I don't think that the United Kingdom's international relations are a matter for the executive at their whim. And they ought to be decided by Parliament any which way Parliament sees fit, first of all. And I would go further. Here's a plea for judicial activism from our judges. The majority reasons in the Miller case suggest that where the treaty prerogative is held by the government, it's unreviewable. Lord Carnwath actually denies that and says that it would have been subject to judicial review if you imagine a Prime Minister arbitrarily triggering Article 50. Lord Reid says that he won't express a view on it. I would hope that in the future, the courts of the United Kingdom are prepared to hold that the treaty prerogative has been exercised unlawfully if they can do so based on justiciable considerations. And all it would take is evidence that the Prime Minister has done something in international relations, anything, including making or terminating a treaty, just to secure the payment of a bribe. There's no problem with the separation of powers there whatsoever. So I do think that that both Parliament and the courts have constitutionally essential roles in regulating the exercise of the prerogative.
Yes, Joshua.
Yeah, can I encourage Lord Pannick to continue answering the questions from his former client and tell us what happens if we get to the stage when there is a vote in Parliament on the agreement and there's not a majority for it? What happens then?
What happens then is the Prime Minister has to resign, I would have thought, because this is plainly a vote of confidence. If the Prime Minister cannot get through Parliament the agreement that she has reached with our EU partners, then that's the end of the government. Either some other Conservative can command a majority in Parliament, or there is a general election. And if the party that wins the general election is proposing that we revisit the question of us leaving the EU, with or without a referendum, then perhaps, who knows, we're all speculating, our EU partners would be prepared to suspend the process under Article 50 until we, the British, decide what we actually want to do. But there are a lot of ifs in your question, and we wait and see.
Yes.
Thanks. Blackstone's definition explanation as to why we need the prerogative in international affairs is that it should be wisely placed in a single hand by the British Constitution for the sake of unanimity, strength, and dispatch. Does that sound, Timothy, like Mrs. May's cabinet to you? But apart from that, I don't think we were anti-executive. I think this whole exercise was to delineate the space for the executive and the space for Parliament. You say that there's no legal authority for the proposition that something is so constitutionally important that it can't be done. If I may, with greatest respect, Timothy, this is a caricature. This wasn't said. It was very simply stated that the 72 Act was a constitutional act. It was par excellence a constitutional act. What could be more constitutional than transferring Parliament's own power to the European Union? So is it up to the executive, however wonderful they are, however pleasant they are, however suitable they are in other areas, to simply at a whim say no, or even not at a whim, just simply to counteract that, to introduce a massive constitutional change, apart from the other legal niceties that were considered by the majority in that respect. Finally, on conventions, I agree that conventions are political arrangements by and large, very difficult for the courts to be involved in them, probably unwise. But conventions, and I was making the point also in relation to our whole Constitution, read books on the Constitution, starting with Dicey and forevermore. Conventions play an enormous part in our unwritten constitutions, and simply to say that they have no special effect, that there's not even a presumption that they should apply. They can be recognized but not validated without explanation. And when a convention has been reduced to a statute, this convention was in a statute, to say, well, it's just replicating the statute as a convention, is that really right? I'm not saying that the decision on conventions was wrong. I understand that the court could do everything possible not to get involved in this kind of political arrangement, particularly in relation to Northern Ireland, but also to Scotland. It's dynamite. But on the other hand, in this kind of a case, was the discussion sufficiently profound so as to guide us on this important question in a multi-layered democracy where it is bound to come up again? That is the question. Finally, I did say, David, right at the end, that I think the Parliament is flexing its muscles much more now under the present withdrawal bill. But it was a bit of a damp squib, wasn't it? And surely you must agree, the first time round, when after all this hoo-ha, after the wonderful work of Mrs. Miller and you and others in this room, Parliament simply, at the end of the day, apart from the debate and the discussion and the Lords thinking they could do something first time round and then second time round saying, we were bound by convention because it was in the manifesto to do nothing at all. In the end of the day, they said, right, Mrs. May, here's you can do whatever you like now, go away and negotiate. Perhaps that was right, but there could have been, for example, the undertaking to come back to Parliament when the deal was done could have been requested in a much stronger form.
Thank you very much, DG.
I wish I could give a proper answer to what you've said about the convention that Scotland and Wales and Northern Ireland ought to be consulted in certain circumstances. And you can imagine a Canadian Supreme Court style reference jurisdiction in the UK courts, or particularly in the Supreme Court, to tell the government what its duties are under conventions. You could imagine that, and you could imagine what I would regard as another constituent act of the judges taking it upon themselves to do that. And I struggle to see the gain for responsible government, because there is no good future for the United Kingdom without the executive acting responsibly in relations, the executive in this city, Whitehall, acting responsibly in cooperation with Scotland, Wales, and Northern Ireland. That's just essential, and if we don't have that, I don't think the judges can solve that problem.
Thank you very much, Timothy. Well, thank you, everyone, for coming and enjoying this very enjoyable evening, I think. The UK Supreme Court has very kindly given us ample time to make our way out, so please continue discussions in the lobby afterwards. And I've also reserved one additional treat right to the end, which is that the UK Supreme Court has also kindly agreed to open the Justices' Library downstairs for you to all have a look at on the way out, and I suggest you do so. It's not ordinarily open to the public, and it's a really beautiful space, so please pop in and have a look on your way out. So thank you very much, and thank you all for your support, and thank you for coming on this evening. So.